Hi everyone, welcome back to Digital Law News, brought to you by Digital Law and produced by Anson Evaluate. I'm Laura Spencer, an apprentice solicitor at Digital Law UK, and this is my Managing Director, Peter Wright. Just in case you don't know, Digital Law is a specialist law firm which focuses on all matters to do with digital and technology, so things like data protection, international data transfers, and everything like that. So I'll just pass over to Peter to introduce himself.
Indeed, thank you very much for that, Laura, and hello everyone. Welcome to another discussion where we're going to go through some of the news and stories of the last few days, and this reflects a lot of the discussions that we have each week in our office with regards to what's happening in the world of digital law and tech.
Yep. So should we get started?
Absolutely, fire away.
Right, so the first story that we're going to be talking about today is regarding India and how they have banned 47 Chinese apps just weeks after they have blocked TikTok and 58 other similar apps over security fears. So India, like I said, have now banned, well, that comes to over 100 apps. Due to the ongoing exercise which highlights the government's seriousness about data privacy and security. And it is estimated that 120 million people in India alone actually use TikTok, making them the biggest international market for the app. So I can imagine this is a huge loss for some Chinese companies.
Indeed it is, and TikTok has been a huge Chinese corporation in terms of its growth in recent years. TikTok was the most downloaded app in America in 2018. That's the kind of scale we're talking about here, and they're valued at $75 billion in terms of how the organization has spread its reach just in a very short space of time. And the interesting thing here is that you're quite right, Laura, of their 500 million users around the world, 120 million of them are in India. So the fact that India is now saying, as a result of the geopolitical instability between India and China following the incursions on the Chinese-Indian border just a few weeks ago, this is showing some of then the real world consequences of that, in terms of this means that TikTok will take a major hit in terms of their reach around the world. I think it's also worth mentioning the fact that India isn't the only country either banning or thinking about banning TikTok. In the US, President Trump has indicated that he would like to ban TikTok, and as a first step, they're looking at banning its use on all devices used by employees of the US government. Because of the, I think, some of the tensions around coronavirus and also world trade, there is a lot of support in the US Senate, in the House of Representatives, and in the Senate, in Congress overall, to potentially ban TikTok in the United States, which will then be a further big blow to it. We should also mention the fact that TikTok was talking about having a new London HQ for its international operations, and they were in negotiations with the UK government about that up until a few weeks ago, before last week confirming they were no longer looking at London after all. So we're looking at this because it's the, with regards to such a massive successful app that so many people enjoy using, we are looking here at nation states turning around and banning its use, which is pretty unprecedented, really. But of course, this is the first time we've had a global app with this type of success that isn't from the United States. Facebook, Twitter, Instagram, WhatsApp, Snap, of course, are all big US popular apps. This one happens to have come from China and is now falling victim to some of those wider geopolitical issues, it seems.
Yeah, and I know, like you said, the growth of this app has been massive, especially over the lockdown, especially with like the younger generation. It seems like that's all that everyone's doing at the moment.
Indeed, I mean, we should add here, Laura, you're from a younger generation than mine, so and I mean, do you find a lot of your friends, other apprentice solicitors on your course, are they big users of TikTok? What's its sort of reach like amongst your sort of circle of friends?
To be honest, well, I don't use it in a way to make the videos or whatever, but I do. It is quite addictive. It's quite similar. I find it quite similar to Vine, how Vine used to be very short videos, like 6-7 second videos or something, but these seem to like a little bit longer. And you just scroll through for hours and hours, and it just gets really addictive. But there is a few people on my course and in like the legal industry who actually make like videos to do with law, and there's some actually some really helpful videos on it. Yeah.
I can't imagine going to much depth in a few seconds though, but clearly it's popular though. Maybe I should take a look before it's banned.
Right, so moving on to our next story. So this is about a British tiny startup British firm that's actually started in the UK, which is the Post Quantum. And they have beaten giant tech firms such as IBM and Microsoft to design an algorithm that may start to protect the entire infrastructure of the internet for decades to come. So they've actually said, their chief executive said that they set up this company in order to save the world from cyber Armageddon. And now they are providing encryption for companies such as the GCHQ and the NCSC and some of the world's largest banks.
Indeed, this is a fascinating story of a British success story. And what's interesting in particular is the fact we're looking at post-quantum technology. And one of the reasons that their product is being used so widely is that quantum computing is now so widely available, having been cutting edge sort of decade ago, 10, 15 years ago, that now frequently quantum computers can be used to then break a lot of the straightforward encryption systems that are out there. Hence, post-quantum is providing something that, in theory, even those devices, even those machines can't actually break. So it's the idea of adding the next layer, a next generation of security. And that is, of course, why the big banks are therefore willing to make an investment in that sort of technology to hopefully make sure that their systems stay secure and resilient at a time of increasing malware and ransomware attacks around the world.
Yeah, definitely. I think it's really good to see that a small, large firm has grown so big in Britain and will continue to grow.
Indeed, it's that sort of brilliant tradition of the eccentric British entrepreneur starting up a company seemingly in their garage and then being able to bring a hitherto unknown technology to the world. And it is a good success story, and it's good that they are getting into these organisations. I just hope it ends up not being sold to someone overseas in the foreseeable future. It'd be nice for it to stay as an asset to Britain once it's now leaving the European Union as well.
Yeah, definitely. So moving on to the next one. So these, like you've just mentioned, the increasing amount of cyber attacks that are now happening. So the Garmin fitness app has actually suspected a cyber attack. So this has caused them to close its call centres, its websites, mobile app, and a number of its other online services. And it's yet known if the hack has led to any customer data being stolen or lost, but they are undergoing an investigation into this. And also a technology site called iPhone has reported that the sports company has actually been hit by a ransomware virus, which they haven't yet confirmed.
Indeed, yes, it looks like approximately a ransom of about $10 million, I believe, has been levied via ransomware against Garmin, according to a few news reports today. And it would appear from the stories that are being circulated that they haven't looked to pay that ransom, and therefore they are looking at being able to restore some of their data from backups and other systems. But they appear to have been hit very heavily by this. This isn't the first time that security issues around mobile fitness apps and trackers has come to light. There was a significant study within the last 12 months that looked at a lot of these apps, smartwatches, I should say. If you declare interest, I have one here, but this one does have some decent Bluetooth security on it. It requires a code between this and when you sync it with your phone, so that you know that only you can access it, whereas some of these trackers and smartwatches don't require that level of security, and there is often a significant risk then with any third party potentially being able to connect to one of these smartwatches, access the data, and of course it's collecting a lot of very sensitive data, things like people's fitness history, name, age, date of birth, along with things like heart rates, where you may have moved, GPS data, so you can work out where you live, where you work, where you go for a run. We're talking about some quite sensitive personal data here, and if that can be easily accessed and hacked, that raises quite significant issues for the safety and security of the users of those systems. Yeah. So this is a significant embarrassment for a corporation like Garmin, and I would expect that they'll want to take some fairly significant measures to protect their security in future as a result.
Yeah, definitely. I think this just seems that the amount of attacks like this are increasing, especially during these times as well.
Indeed, I think sometimes it's been down to the fact that during the lockdown, use of many networks has increased while we've been at home without access to gyms and things. So things like fitness apps, the use of those has skyrocketed. So therefore, even more data is being collected, even more things being carried out using them, and therefore the risk increases.
Yeah, definitely. So moving on to the next one. So we did mention about this in our last episode last week. But we will be talking about this in more detail in an upcoming webinar, which will be a joint webinar between Digital Law and Anson Evaluate. We just wanted to touch on this in the session today. So the ICO have updated their statement on the judgment given by the European Court of Justice in regards to the Schrems case, Schrems II case. So the European Board of Data Protection have now issued a 6-page document of its FAQs on its invalidation of the Privacy Shield, and they can be accessed using the link on the page, which is available if anybody wants these slides afterwards.
Yes, so the Privacy Shield, the understanding of the judgment continues to develop. This story refers to the fact that we've had more guidance from the European Data Protection Board and the ICO. The ICO's guidance, though, is sparse, to say the least. It's one paragraph saying we're thinking about this, whereas the guidance from the European Data Protection Board is 6 pages long, is probably more for specialists in the field. Anyone with a corporation thinking, well, what do I need to do about this, might be a little bit confused reading through the data that's out there. So we will indeed be running a webinar to go through this in more detail. I think the thing to bear in mind at the moment is that the regulators are certainly saying for anyone looking to send personal data from a location in the European Union to a location outside of the EU, the United States, do not rely on the Privacy Shield anymore. If you were previously relying on the Privacy Shield, you're okay to do that for the short term. Yeah. They're saying basically as you were, but for the future after that, they're saying that there will be a matter of then relying more on standard contractual clauses, which is a significantly bigger responsibility on companies to make sure those clauses are in place and are being enforced, and indeed their continued use will be under question, given that part of the judgment refers to the fact that, well, it's still well and good, but can companies in America really say that they can confirm that those standard contractual clauses are in place when some of the surveillance programs that they have are so intrusive that arguably any data of foreign citizens being imported into the US is going to be subjected to surveillance and therefore would fail an adequacy test from the European Union in terms of the adequacy of the data protection measures for the protection of personal data in that state. So this is a massive, massive problem in terms of the sharing of data between Europe and the US. It is a problem. It was a problem up until the year 2000 when they brought in the safe harbour scheme. It was still a problem because safe harbour wasn't adequate from 2000 to 2015. That was then struck down by the Schrems I decision in 2015.
Yeah.
And even then, the Privacy Shield, when I started advising clients on it from 2016, I said, this is not going to last very long. And to be honest, I am surprised it has lasted as long as it has, but it was never going to last as long as, say, the Privacy Shield, the Safe Harbour had from 2000 to 2015. It's never going to get to double figures, bless it. As it was, it barely made it to 4 years. And I think the likelihood of any other scheme being agreed between Brussels and Washington in the short term is remote.
Yeah.
So basically watch this space. I think a lot could happen over the coming months, partly dependent on the US presidential election and partly dependent on what the regulators now decide to do, and partly dependent on the fact that Max Schrems is now looking to undertake litigation in relation to the standard contractual clauses. So this is going to run and run and run, and we'll be that's a whistle-stop tour of the issues. We'll be talking about it in far more depth in our webinar that will be coming up in August.
Yeah, so that's going to be taking place probably the week commencing, I think it's the 10th of August, but we're just waiting to confirm an actual date on that. So keep an eye on our social media platforms, and it will be posted on there, and it will be mentioned in the next week's webinar as well. So moving on to our next slide. This one is regarding video teleconference platform and providers. So obviously the uptake in things like Zoom, Microsoft Teams and everything like that has grown over the last couple of months due to the ongoing crisis. However, the data protection and privacy authorities around the world have now published an open letter which can be viewed on the ICO website. And this is an open letter to video conferencing companies, reminding them of their obligations in order to comply with law and handle people's personal information responsibly.
Yes, it's a very interesting letter. It doesn't mention any of these video conference providers by name, and of course it's proliferated out there. There's loads of different ones. There's the ones that we use to speak to our clients that we hope are, well, we know are very secure. But then there are other providers out there that aren't quite as secure. There are three things that I thought were quite interesting in the letter. One was the fact it asks these conference providers to think about privacy by design. That means that you are carrying out things like a DPIA, data protection impact assessment, ahead of the design and build of the system, so you can identify risk and build necessary security measures in from the start. However, the efficacy of that is undermined when, for example, the UK Department of Health and Social Care didn't follow privacy by design with the design and build of its own test and trace system.
Yes.
So it's one thing to say, we want to see this. It's a problem then when you see that being undermined by other branches of government. Yet it is certainly good practice, and it's something that we work constantly with our clients to do to help them to undertake a DPIA and to then make sure they can incorporate the findings from that into their systems. The second thing it says is know your audience, because you can have a system that might be quite fluid with how it handles its data if that's only going to be used for fairly straightforward vanilla purposes. So, for example, if you're only going to be perhaps speaking to family or friends about social plans and things, you might not, there's no real need to make sure there is fundamental security in place on that. You're not going to be discussing your will or your bank account information or your medical health records on that sort of call. So it's only then just the personal data of those involved. So if you want to use, Facebook Messenger or WhatsApp to have that video call, fine. But it's a matter of then knowing, don't use that if, for example, a GP practice shouldn't be using that to undertake calls to its patients, for example. A law firm shouldn't be using it to speak to its clients. So it really comes down to knowing your audience. These companies need to think about who they are marketing these to and making sure they are not encouraging businesses to break their obligations to their customers in relation to security and confidentiality potentially. And then finally, transparency, which is interesting because a lot of these companies use technology or use systems where it's not particularly clear where the data is stored. It's not clear what security measures might be in place. It isn't necessarily clear where the ownership of the data and anything that's recorded is then going to be kept. So that element of transparency, being clear with the users that this is how the system operates, should be encouraged as well. And that's just three of the things that this open letter encourages video conference providers to be doing. So it's an open letter. Let's see who decides to actually act on that and if they decide to follow through on any of the recommendations that they're asking for.
Yeah, definitely. I know to do with the transparency point you said, the platform we use, when you actually go on to the website, sets out a list of all the questions you'd want to ask, and other platforms are not as transparent. So that is a thing to look out for, especially. Exactly.
I hope that more platforms follow that example.
Yeah, definitely. So moving on to our next one. So this one is by the NCSC. So the UK NCSC and the US CISA have put out a joint alert into the QNAP NAS devices. So there is a current investigation ongoing into a strain of the malware called QNAP, which is also known as Derek, which attackers used in the late last year to target network attached storage devices which are manufactured by the firm QNAP. So these devices, if you do have one, it may be potentially vulnerable to the risk of the QNAP malware if they are not updated using the latest security fixes.
Indeed. The main takeaway from that story is always make sure your devices are properly updated. So
yeah,
manufacturers are always providing all their fixes and patches and updates to their systems to try and close off these sorts of risks. Very often they are not updated for various reasons. Particularly some companies might delay rolling out an update because they fear it might unsettle some of the other devices and apps they rely on for business critical purposes. But that can then mean you are leaving yourself wide open for a risk of malware and even worse, ransomware. Though the idea of receiving a notification here from the NCSC saying, be careful, you might be at risk from Derek. It's difficult to take that straightforward if you receive that notification. And of all the names they could have chosen, they chose Derek, but there you go. But it's just making the point that whatever system you're using, whatever device, they can be at risk if they are not properly updated.
Yeah, and like you said, that just reinforces the point that once these updates come through, you should be doing them straight away.
Yeah, I mean, there are many examples, aren't there, Laura, where we've ended up looking at examples of cyber attacks, and so often it comes down to the fact that updates have not been installed, or the business thought they were fully up to date, and it turns out they were not, and they were using either old, out-of-date, unsupported versions of programs, operating systems, internet browsers, and that's where the problems usually stem from.
Yeah, definitely. So moving on to our next one, still staying on the theme of cyber attacks. So you might have heard in the news recently, the big Premier League was actually attacked by a cyber attack. So the NCSC have now done a report on this, and they've highlighted some of the risks. So they're saying things like blocked turnstiles, transfer deals, and fraudulent equipment sales are among the incidents targeting sports sector. And they're now saying that at least 70% of institutions actually suffer a cyber incident in just 12 months period. and they're now urging sports organisations to implement new cybersecurity measures so they don't also fall victim, like we have seen over the last couple of weeks.
Indeed, so there was a story last week about a Premier League club that almost fell victim to a scam in relation to a player transfer fee and almost ended up wiring £1 million to a fraudulent account.
Yeah.
But this highlights the fact that these systems very often are open to being compromised. Though, ironically, if the turnstiles were blocked right now, it wouldn't make a huge amount of difference with the fact we can't get crowds into the stadiums anyway. But we wouldn't want that to happen once they can start letting the crowds back in. And there have been 2 cricket games over the last week where they've started letting an audience in on a limited basis just to see how that operates. So that 2-day game was part of a pilot that the UK government was operating. So we might start seeing limited crowds back at certain events in the not too distant future. And therefore, where you do have people ordering their tickets online, we don't want that data to end up being compromised. And very often, for whatever reason, sports institutions, sports teams, clubs haven't sometimes made the investments in security around their systems that you might have otherwise expected. So during this period, when they might not be selling as many tickets as they have in the past, actually now is the time to look at their risk, put a plan in place, start procuring some secure systems that can help them with regards to the integrity and security of their systems, and be able to demonstrate to a regulator that they're doing all they can to protect the personal data of their fans and indeed of their suppliers and other stakeholders who might be at risk from these sorts of things.
Yeah, definitely. And then I think this is the last one. Yes, that's the last one. So the final one we're going to talk about is the Into the Russia report, which was, I think it was released last week. So Boris Johnson is preparing to give security more powers to stop foreign interference in Britain under new laws to combat the threat of the Russian spies. So the government are now saying they actually took the eye off the ball in terms of everything that's going on with Russia at the moment.
Indeed. So this relates to the report published by the Intelligence and Security Committee of the House of Commons last week.
Yeah.
This report, it contains a package of recommendations. Whether any of them will actually happen or not remains to be seen. But the point is that they highlighted some of the areas where Russia was seen to have potentially been funneling state money from Russia into the UK via covert means, and also where they may have had a high number of intelligence operatives operating in the UK. Now, the idea of that necessarily being, a register for spies may be a bit of a sort of tabloid-esque way of putting it, but very often a lot of the intelligence staff for foreign countries that operate through things like embassies, consulates, etc., very often the host country does know which staff are actually engaged in intelligence and surveillance work. So it would actually be looking at trying to move towards some form of registration for that. We aren't talking about having the equivalent of James Bond signing a register when they land at an airport, but we are looking at a little bit more in the way of perhaps clarity between the countries that are sending these agents and their security personnel into those countries where they are just following more straightforward administrative tasks. This goes back, of course, as well a couple of years to the Salisbury poisonings, recently dramatised on TV. And as a result of that, those poisonings of 2 Russian nationals in Salisbury in the UK by Russian agents, both the UK and America ended up expelling dozens of personnel from the Russian embassies and presences in their countries. And even though it's not confirmed for sure, but it's basically known that those people were working in intelligence and surveillance, that's why they were asked to leave. So actually the governments in Washington and London did know full well who those people were. And then they just said, look, no joke, actually you will have to leave now. And they were expelled, their visas were revoked, and off they went. So it's not actually as difficult to have a more clear register in place to do that than it might seem. Interestingly, the authors of the Intelligence and Security Report, Security Committee's report, do estimate that actually the true number of Russian agents working in the UK could be far higher than has been originally thought in the past. So having some measures like this to, if anything, just focus attention of the UK government on the risk and do more about it, might be a prudent measure to take in future. Yeah,
definitely. And just referring to the dramatised programme that was on, I did watch that. It was really, really good.
I should try and watch it if it's still on iPlayer or ITV Player, whichever one it was.
Yeah, I think it was on the iPlayer.
Yeah.
So just a quick mention as well. Do you want to talk about this, Peter?
Yes. So we have a special offer for our viewers and listeners. If you're interested, we have a GDPR compliance manual for law firms. This contains forms and templates and checklists. We produced this in 2018 for our clients, and it was very, very popular. It's been updated to reflect current standards, and we're also working on versions for other sectors, including education, healthcare, financial services. But in the meantime, we have the original version of it here, the compliance manual for law legal practices, is now £99. That's a reduction of almost 50% from its original price of £195. You can have the digital copy, or you can have a hard copy as well for £5 postage and packing on top of that. And this gives you the practical tools you need to establish data protection measures to comply with GDPR in your organisation. So we have that on there. If you're interested, please drop us on an email on admin@digitallawuk.com and quote that you've heard the promotion on this webinar, the Digital Law News webinar, or the Digital Law News podcast, whichever of those you've heard, and drop us an email on admin@digitallawuk.com.
Great. Yeah, so that's everything for today. So I just want to thank you, everyone, for listening. Just to let you know as well, this is now available on a podcast, like Peter has mentioned. So it's available on Apple and Spotify and some other platforms as well. And these will be carrying on and occurring as a webinar on every Tuesday at 4 p.m.
Indeed, so register to join us live at 4 o'clock on a Thursday afternoon, or download the podcast or webinar and watch it or listen to it at your pleasure. But thank you for listening, and we'll see you next time.
Thank you for listening, everyone. Goodbye.